Welcome to Motivation at Hand. To know is to know how. Make your foot the foot that counts. In the courtroom, the question does arise. A 3-judge panel of the Federal Appeals Court in Washington skies. Of absolute immunity for Trump's disguise. Can past actions be shielded from justice's call? In legal battles, the debates unfold. As indictments facts are told. The Constitution's words, the judges explore. Seeking fair play, what more? Is justice the real seed? To be a democracy, justice is what it need. So in this question, the nation reflects. What are the principles America do you want to protect? Jurisdiction. The top contender in the Republican presidential primary made an appearance on Tuesday, January 9, 2024, at the Federal Appeal Court hearing in Washington, D.C. His legal team was present to convince an appeals court to dismiss the case, accusing him of plotting to overturn the 2020 election results. The 3-judge panel at the U.S. Court of Appeals for the District of Columbia Circuit greeted the defense's argument with skepticism from the very beginning. At the start of the arguments, before the attorney representing Trump had a chance to present the case for immunity, Judge J. Michelle Childs steadily questioned his attorney D.JohnSauer about whether it was appropriate for the court to consider Trump's appeal at this point. Typically, in most criminal cases, issues cannot be appealed until after a trial verdict, except in specific circumstances when a defendant can make an immediate appeal. Smith's legal team did not contest the appeals court's authority to address the immunity issue before the trial. However, a watchdog organization named American Oversight submitted a friend of the court brief arguing that the appeals court did not have the right to consider the issue at this stage, citing Supreme Court precedent. If the appeals court agrees that it lacks jurisdiction, it would send the case back to the trial court without resolving the immunity matter. Trump's lawyer, D.JohnSauer, argued that presidential immunity is a matter that should be resolved before a trial, citing legal precedent to support the notion that the appeals court was correct in considering the immunity claim at this time. The crucial question of whether a president who orders a highly secretive and lethal military unit to eliminate his political adversaries should be shielded from criminal prosecution was at the heart of a troubling exchange during today's pivotal hearing. This hearing aimed to determine if Donald Trump should be protected from criminal prosecution for his efforts to overturn the 2020 election. The exchange occurred as all 3 judges on the panel expressed doubts about Trump's legal team's assertion that the former president is entitled to complete immunity for his coup attempt, a claim that, if successful, would effectively halt the special counsel's election interference case before it goes to trial. The exchange unfolded as follows. Could a president issue orders to SEAL Team 6 to eliminate a political rival? Is that considered an official directive? Inquired Judge Florence Pan. Trump's attorney, John Sauer, hesitated, invoking the intentions of the Founding Fathers and what they might envision in such a scenario. I posed a straightforward question, Judge Pan interjected. Could a president who instructed SEAL Team 6 to assassinate a political rival who had not been impeached be subject to criminal prosecution? My response is a qualified yes. There is a political process that would need to occur within the framework of our Constitution, which entails impeachment and conviction by the Senate. The absurdity of this argument cannot be emphasized enough. Nonetheless, this is the same individual who utilized his executive authority to pardon service members indicted on war crimes. Even though today's question was an extreme hypothetical, a method frequently employed by judges to assess the rationality of a legal argument, the response from Trump's legal team was consistent with the former president's public stance. Trump has frequently hinted at plans to incarcerate his political adversaries and has recently floated the idea of Indicting Joe Biden if he were to return to the White House. Regarding the concept of implementing authoritarian strategies to deploy the military against his opponents. It may align with his aspirations of a temporary dictatorship. A significant portion of Trump's argument centers around the assertion that the Constitution shields him from prosecution due to the U.S. Senate's acquittal in his historic impeachment trial related to the January 6, 2021, attack. The defense contends that the Constitution's impeachment judgment clause implies that a president can only face criminal charges if they are impeached and convicted for similar conduct. Appeals court judges indicated on Tuesday that they are likely to reject Donald Trump's arguments for immunity from prosecution in his case involving election interference. This perspective became evident during the proceedings, which delved into various political and legal dimensions. While the judges did not specify a date for their decision, the timing is crucial, given the impending trial date of March 4. Trump's legal team, aiming to delay the case until after the November presidential election, is prepared to elevate the matter to the U.S. Supreme Court if the D.C. Court sides with special counsel Jack Smith. However, Judge Pan emphasized the statements made by attorney David Shane, who represented Trump during his impeachment trial as he urged senators to acquit. During that trial, attorney David Shane asserted that there exists a judicial and investigative process in the country to which no former office holder is immune, advising senators, that's the process that should be running its course. Judge Pan repeatedly pressed Sauer on whether he believed Trump could face prosecution in this case if he had been convicted by the Senate. Sauer acknowledged that prosecution could potentially be pursued in such a scenario but stopped short of conceding that this particular case would be appropriate. He informed the judge that there were numerous other issues associated with it. Pierce, the prosecutor on Smith's team, argued that Trump's impeachment argument is flawed for several reasons, including practical ones. He contended that it would imply that if a former president engaged in actions like assassination or selling pardons and was not impeached and convicted, there would be no accountability for that individual, which he found alarming. In the midst of uncertainty, we watch the scene. With cases in Georgia, D.C., and Florida, yet to convene, the 2024 election's future hangs in the air. As justice moves forward, with a weighty affair, we tread a complex terrain. Amid questions and strain, we wait. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.